Is it what we should assign that bound basics? That act in the name of the people?
Hello, I'm Patrick Omoni. Today we are going to continue our series of exposure of what is happening in the judiciary, the least criticized institution of this country, yet it plays a very critical role in ensuring the happiness, the peace, and tranquility of society. Now, because we have not been focusing on the judiciary with a very critical eye, a lot has gone wrong with the judiciary. And just unpacking what has gone wrong is just mind-boggling. Looking at what has to be done in order to put things right is far beyond what anyone can imagine, coupled with the fear that people have of the judiciary, the fear that people have of judges.
You may end up in New Zealand.
The fear that people have of judicial officers, forgetting that the powers that they wield, the powers that they exercise on us, we are the ones who gave them that power under Article 126 of the Constitution. So it is not a power that they get that comes from them as people. They are not powerful because of some kind of genetic trait that they have, but they are only powerful because we gave them that power. And after giving them the power, then we start fearing them. We can't criticize them. That power is to be exercised in our interest. They volunteered and requested to be placed in those offices so that they can do a duty that should have our interest placed at the highest pedestal. So today we are going to look at the scam that has been happening in the judiciary. The scam is the creation of divisions of High Court. The Chief Justice, in his annual performance report for the financial year 2022-2023, the Chief Justice, in his reported an existence of 7 divisions of the High Court. The gist of the matter is that these courts are unlawful. These courts are not real courts. It's a scam that the judiciary has created within the judicial system. Matters that go into court are put under 2 classes, and that is under criminal and civil matters. That is all. And when handling matters at the High Court was given unlimited jurisdiction. That means it can handle all kinds of matters. Under Section 138, the Constitution gave the Chief Justice the powers to extend the court services of the High Court closer to the people. In other words, the High Court could sit in a place that is nearer to the people, where people can access the court services. But the High Court continues in that extension towards the people. It continues sitting in its unlimited jurisdiction, handling all matters and handling cases that are of criminal and civil nature. So that is how the High Court operates. However, we are beginning to see that in the report of the annual report of High Court, the Chief Justice listed 7 courts, divisions of court, within the High Court. Now, the authority to do that is not with him. He was not given any authority to do any of that division of a court. No one was given the authority to divide High Court into division. Instead, the only authority was given to the Chief Justice to divide the Court of Appeal in Constitutional Court and the Court of Appeal. The rest, High Court, just remained with its unlimited jurisdiction, not divided into any divisions. All judges sitting in the High Court are all of equal ranking, and they all report to one person, who is the principal judge. However, with the creation of these divisions, we are seeing that judges are beginning to report to their fellow judges and not to the principal judge. And there is evidence of that where judges of the divisions are calling cases of their interest from the respective judges who sit under them, which is a stark contradiction, which is an ultra-vires act, using authority which you don't have to call a case from a judge. Once a case is reposited on the office of a judge, that judge is duty bound to do two things to that case: adjudicate on it and arrive at a conclusion, or return it back to the registry. Because the judge has a duty to dispose of a case which has been allocated to him. And then also, once a case has been allocated to a judge, to remove that case from the judge's office, it requires very good grounds. This is how the judicial system is protected, to avoid these issues of a case flying from this judge to the other judge, like we are seeing it today. So any judge that will allow a case that the registrar has forwarded to his office to just simply be removed. Now, we all know what happened with a case. I don't recall the case very well, but this was a case where it was under the custody of Justice Mubiru. And I think the litigants wanted the case removed from him and taken to another judge, transferred to another judge, but they went to the Chief Justice. Now, the Chief Justice ordered Justice Mubiru to release that file, and Justice Mubiru declined. Now, this is the Chief Justice, because he knew that the Chief Justice does not have that power to order him to. Position of the Chief Justice is just administrative, but in terms of the judicial process structure, the judge is supreme in regard to a case, and the only person who can remove a case from him is the principal judge. So that is how serious it is. However, what we are seeing today is judges are just forwarding cases from amongst themselves without the authority of the principal judge. And this is happening within the divisions of court, which is a matter that has to be looked into. So before going into the troubles that we are seeing, the maladministration of justice that is happening in these divisions of court, let's first address the issue of whether divisions of court exist or not. Then from there, in the next video, we are going to be looking at some of the harms that are being caused on the litigants by people who are sitting in these divisions of court and the way they are doing it. Then we also want to know what becomes of a person who sits in a place which is not designated as a court and continues to discharge services as a justice of the court. Swear the oath with a sworn oath, a constitutional sworn oath, and then you come and you sit in a place which is not designated as a sitting place for a high court, and you sit there and you start discharging judicial duties. What does it mean? So that one will be on a separate video, on another video. But in this video, I want to prove to you that divisions of court, all the 6 divisions of court that the Chief Justice mentioned, are not lawful, they are illegal, and they have done it without authority. Now let us go and see how the High Court was constituted. Under Article 126, it reads that the judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with the values, norms, and aspirations of the people. Under Article 129, it reads, the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of the Supreme Court of Uganda, the Court of Appeal of Uganda, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including quasi-courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. Under Article 138, High Court was created in the Constitution under Article 138. And in it talks about the High Court shall consist of the principal judge and a number of judges of the High Court as may be prescribed by Parliament. The High Court shall sit in such places as the Chief Justice may, in consultation with the principal judge, appoint. In doing so, the Chief Justice shall, as far as practicable, ensure that High Court is accessible to all the people. Okay? So there again in under Article 139, the High Court shall, subject to the provision of this Constitution, have unlimited original jurisdiction in all matters and such appellate and other jurisdiction as may be conferred on it by this Constitution or other law. Subject to the provision of the Constitution and any other law, the decision of any court lower than the High Court shall be appealable to the High Court. So, just leaving it at that also, you don't see anywhere where the Chief Justice is given powers to create, to fragment High Court into divisions like the way he has done today, into the 6 divisions. And what that has done is that it has reconstituted the jurisdiction of High Court and limiting it to handling specific matters, land matters, civil matters, commercial matters. Civil matters should be taken to civil division. So by doing that, the Chief Justice has actually created divisions in the High Court and unlimited their jurisdiction to handling those matters. Now, there is no power because High Court is unlimited, and he has changed it from being High Court with unlimited jurisdiction to High Court with divisions with limited jurisdiction. That is what it means. You see? So each time you take your case to, say, commercial division, and the people in commercial division think, oh, it is a family matter, they will claim they are unable to handle it. So by doing that, the courts are actually negating from their constitutional duty that granted them unlimited jurisdiction to handle matters of all nature, and which is a violation. It is actually a violation of the Constitution. When the Constitution delegates a duty to you, then, and in the event you fail, you have actually traversed the Constitution. And that is what we are seeing here in all these divisions of court. The thing is that a real court is a court constructed under the Constitution. So anything that is built without the authority of the Constitution is not the constitutional court. It is something else. So which begs the question, what can we call them? Because already the sitting place has not been designated by the Chief Justice. The people who are sitting there are judges, and I hope that they have sworn oath. Okay? That is also something that we want to find out, whether the judges have actually sworn the oath of office or they are not judges. We are also suspecting they may not be judges, as according to the Constitution. So the whole thing is a scam that is unfolding. And this is going to impact so many of the decisions that have been made by those people who are sitting there. I don't call them judicial officers because a judge is constrained. The actions of a judge are constrained by his oath. A judge who has made an oath, who has sworn an oath, cannot go and sit in a place that has not been designated as a sitting place for High Court. So when the issue is given to a person who has sworn an oath as a judge to go and sit and dispense duties of a judge in a place, the first thing that person needs to ask is, has that place been designated by the Chief Justice as a sitting place for High Court? If not, you don't go there. But if you go there, whatever you're doing is null and void. Because first of all, you're not sitting as a judge. You're not sitting in a sitting place of a judge. So we are going to study this further and find out what is the impact of all this on the judiciary. But also, there are so many funny things that have been happening in these divisions of court. Like, for example, this incident.
You don't determine before this court. You don't decide for me. If they've been
doing it for other judges? Sorry. You cannot tell me that you're going to appear before me and urge orally.
Name of the people.
What is that you're talking? Now when I say it is rubbish, then you say, I've said.
Is it rubbish aside that bound the basics? That's actually the name of the people. We are the parties.
Mr. Mele, you push me to the extreme. And I can do extremes. You may end up in New Zealand.
You see, a real sitting judge cannot make such a statement. That's why we're beginning to doubt. A sitting judge cannot make such a statement and get away with it. But we have seen him make that statement and then later on issue an order to have this gentleman arrested. And he was arrested and put behind bars for 18 months. So this is what is happening there. And in the event it is found that this place has not been designated as a sitting place for High Court, and the people who are sitting there are not judges, or even if they are judges, then they have violated their judicial oath of office. And so the law should act on them like any other fraudster would, because fraud vitiates everything. Once you're caught in an issue of fraud, there is no immunity for you, except maybe the president, who when he's caught in a field, but also it is only the immunity for as long as he's still a sitting president. The moment he's out of office, then litigations can now begin on him. So that is what we are going to be looking at going forward. So I also urge some people who may be having the view that I have in terms of calling out the judiciary on those scam, fraudulent activities that is happening there. I urge you to contact me so that we continue with this push, because I need a lot of information so that I can put my thoughts together and put them out in the public. Because this is not just informing the public, but we hope to start major litigation. We hope all this should culminate into a commission of inquiry that would fish out all those who are behind this fraudulent system. But underneath it all, the foreign forces, the donors, and all these other financiers of the judiciary appear to have a hand in it. And what we need to do is to pull out these problems and put them out there. Right now, we have written to the Chief Justice to give us a copy of the contract, the loan contract, the loan service agreements that they have with the different financial institutions. Because we know that all the continuation of those, the performance of those contracts is pegged on the adherence to the rule of law by the entities that are bound by the contract. So in this case, you have the judiciary with the financial institution, whom they have not disclosed anywhere yet. But we hope he will respond to our letter and give us that contract, and then we'll write to them and tell them if the judiciary is not upholding the rule of law, then they should sever their financial flow to the judiciary. That contract must be put on hold or terminated. And if they don't, then we are going to appeal to their citizens, the countries where those institutions are registered. So that is what we are going to do. So basically, the High Court is not divided into divisions of court. The Chief Justice has failed to provide proof of the instrument that created those divisions. If anything is not created by an act of parliament, it is not created by the institution, that means it has been privately created. So we need to find all those things out. So we have also written to these judges that are sitting as heads of divisions. We have requested them to give us their oath of office and also the instrument that appointed them in those capacities as head of division and deputy head of division. We have also, and also to give us the proof of the instrument that created those divisions, because they are the ones who can present it to us. If the principal judge cannot, if the chief justice cannot, then these judges should be able to give it to us. Because we assume, giving them a benefit of a doubt, that when they were, upon swearing their oath, they asked the employer where to be deployed and they were pointed to the divisions of court. Remember, ignorance of the law is not defense. There are people who should have strong command of the law. And that means when they were told that they are going to sit in a division of a court, at that point they should have questioned the legality of that entity. And if they did not, and went ahead and started sitting in those places, then they are also complicit in that crime of defrauding people. People go there and remember, the consequence of going to a place which is not designated as a court, that means whatever adjudication that is going to be dispensed on you, what you're going to be serviced with, it cannot be called lawful because the whole process, the ground is rotten. The place where you are sitting is not acceptable. It's not a court of law as created by the Constitution. So this is a huge scam that we are going to continue unpacking slowly, and we see where to go with it. But a lot of harm has happened to people. If these people are not judges, because when an individual is not sitting, is he sitting as a judge or just a mediator? Who are they? What capacity are they sitting in those places? And when matters are placed before them, what authority do they use when they're acting on the matters before them? They act on those matters under what authority? Is it under the authority of their judicial oath or what? So that is what we need to know, and we are going to start unpacking this slowly. But all this appears to be behind the skyrocketing backlog cases that the judiciary keeps reporting. Because when you go to most of these divisions of court, the judges absent themselves according to their whim, the way they feel like. They don't care whether their matters are before them, and then they like pushing matters, very future dates. And then they delay to deliver their rulings. I think this is a scam that people need to wake up to. All Ugandans must put all their interest in this so that the judiciary is cleaned up. Without a clean judiciary, then we don't have a country. We do not have a country without a clean judiciary. If you have a judge who can just, with a stroke of a pen, knowing it to be wrong, order for an arrest and imprisonment of a litigant because he just made statements against a judge, then what about if the judge is now interested in your property? Or if those guys who are behind the judges are interested in your property? They're interested in your job. You think you're going to get justice? Certainly not. And that's why every Ugandan needs to focus now. We need to focus and get this thing off the way. We need to call out the judiciary, the judiciary and the donors, most especially the donors, because they are the ones who are financing this. You see? They are the ones who are financing this.